All right, take it away.
All right. So hello, everyone. My name is Richard Wallace, founding executive director of Equity and Transformation. Also sit on the policy table and the strategy table with the Movement for Black Lives. And I want to welcome you to our panel discussion today on how we respond to the seismic shifts on the Supreme Court. We're going to start by doing a quick round of introductions. Also let you all know that there is a space here for Q&A. If you look down at the bottom of your screen, you will see Q&A, and you can pop your questions in there as they pop up. You can also use the chat to communicate however you choose to communicate, whether it's love or disagreement. Yeah, and so we're going to be in discussion today. And so I will pass it around and let everybody kind of introduce themselves, and then we'll go into some questions, and then we'll also take some questions from the Q&A at the end. So I will pass it to April to start.
Hello, everyone. I am April Albright, and I am the legal director of Black Voters Matter Fund. We are an organization that is, we consider ourselves to be a power building organization. And we work in 15 states in this country, specifically in Black communities, around policy and around, using electoral politics in order to, continue our struggle for liberation in this country.
Welcome, welcome, welcome. Rhea?
Hi, my name is Rhea Salter. I am an energy justice attorney and activist. I'm the founder and executive director of the Energy Justice Law and Policy Center, the nation's first law and policy center focused on energy justice. I'm a law professor adjunct at Cardozo Law School. I'm a member of the Movement for Black Hives, Black Hive, and I'm headed with the Hive to COP27 in Egypt.
Welcome, welcome, welcome. Alec?
Hi, everyone. My name is Alec. I'm the founder and executive director of Civil Rights Corps, which is a nonprofit organization based in Washington, D.C., working all across the country, challenging the injustices of the criminal punishment bureaucracy. We're an abolitionist organization that is trying to dismantle the criminal punishment system and replace it with systems that actually promote health, well-being, and safety and human flourishing for all people. And it's really, really an honor to be here to talk with you all tonight.
Welcome, welcome, welcome. And Victoria?
Hi, everyone. My name is Victoria Kirby York. I am the Deputy Executive Director at the National Black Justice Coalition. I use VKY, she and they in place of my name, if you happen to need to use it. And the National Black Justice Coalition is the nation's premier civil rights organization focused on the Black, lesbian, gay, bisexual, transgender, queer plus, and same gender loving community, including people living and thriving with HIV and AIDS. Our policy agenda includes civil rights, of course, health and wellness, tech justice, because there's a lot of civil rights infringements on the internet. So that's something that's really important to us as well, in education and workforce development. So excited to be with you all tonight to talk about the Supreme Court because they impact all of it.
Indeed, indeed. And welcome, welcome, welcome. Gerline, I want to make sure I don't, Gerline?
Thank you, Rich. Yes, Gerline.
Okay.
Girl in, very simple. My name is Gerline Joseph. I am the co-founder and executive director of the Haitian Bridge Alliance. We are the only Black-led Haitian female-led organization at the US-Mexico border, addressing Black migrants arriving from the Caribbean and the continent of Africa. We understand that immigration is a racial justice issue. Immigration is a human rights issue. And the Supreme Court really impact how we view migration. And we want to make sure we center the realities and lives and voices of Black immigrants, understanding that 20% of Black America are first-generation immigrants or people who were born in a different country. So it is imperative that we continue to move within the Black diaspora as one. I am calling on a family reunification, of family unity, because I am a descendant of enslaved people in the Americas and also an immigrant from Haiti, Black Haitian American woman. In addition to that, we co-created the first Black Immigrants Bail Fund to address high bond for Black immigrants who end up from the criminal justice for smoking a joint at the corner in Brooklyn, end up in prison and then transferred to immigration prison and then deported. And at the end of it all, we also created the Cameroon Advocacy Network, because in 2018, we realized we had a big number of Cameroonians being imprisoned as asylum seekers, and we fought to win TPS, temporary protection for Cameroon. So we are really looking forward to address how the Supreme Court and other courts around the country impact Black immigrants and the Black community at large. Thank you so much for having me.
Thank you, and welcome. This is gonna be I already feel like this is gonna be a very lit conversation, so I'm excited to get into it. And the way it'll roll out is I'm gonna give a quick overview of the decisions that I think are most important for us to watch out for and to keep our eye on, and also, and then we'll go into a discussion where we have a few questions for the panelists, and they can give their perspective through their lens, and then we'll go into questions that are added to the Q&A. So again, my name is Richard Wallace. I'm the founder of Equity and Transformation. Shout out to, also known as EAT, and we work with Black informal workers. And so what I want, I think the things that stood out to me is that, we'll start with Dobbs versus Jackson and Roe v. Wade. Oftentimes people see the latter end of it and they saw Roe v. Wade, but there's some things that happened preceding that led to this, right? And these are also organizing tactics, right? So I think we often think that we're the only folks organizing. Like, no, in fact, they have organizers who are moving strategically and they have long-lasting campaigns. And this was a result of one of their long-lasting campaigns. So a case in which the court overruled Roe v. Wade and Planned Parenthood, eliminating constitutional rights to abortion. In 2018, Mississippi passed a law called the Gestational Age Act, which prohibits all abortions with few exceptions after 15 weeks. On Friday, June 24th, 2022, the Supreme Court overturned Roe v. Wade, holding that there is no longer a federal constitutional right to an abortion. That decision ended the constitutional right to abortion and left it up to states to decide. As you know, many people in states across the country will have access to abortion care, but there are 13 states that had trigger ban laws that immediately made abortions illegal, with 13 others soon to follow, right? As it relates to the other piece that we're going to be discussing today is affirmative action. So October 31st, the Supreme Court heard two cases concerning affirmative action, and they were led by Students for Fair Admissions versus President and Fellows of Harvard, and the Students for Fair Admissions versus the University of North Carolina. The attack on affirmative action has been in motion since then President John F. Kennedy signed an executive order directing the use of affirmative action in federal governments in the 1960s. Today's anti-affirmative action movement is led by a racist named Edward Bloom, and he's a conservative strategist, and that this is part of his organizing campaign, right? And I want to make sure that we continue to put this in context to organizing, right? Because I think that's the tie that brings most of us together. As it relates to voting rights, which will be another topic that we'll discuss today, the Supreme Court, this term we'll hear Merrill versus Milligan, a case concerning Alabama's congressional districts that may have serious implications for the power of the Section 2 of the Voting Rights Act. And I think most people are demanding or hoping that the Supreme Court reject Alabama's dangerous invitation to remake the Voting Rights Act into a law that entrenches rather than fights against racial discrimination and voting and other key issues. So the first question that I have for the panelists is, how do the Supreme Court decisions impact your advocacy work? And everyone will answer this question, and then we'll go into questions that are specific to each one of you. And I'll start with Victoria, because I see you off mute.
Well, yes. I mean, the Supreme Court has impacted every aspect of the work we do as a Black LGBTQ+ and same gender loving organization. Unfortunately, we haven't had the kind of majorities in Congress and in the presidency or the will to move forward on modernizing civil rights law in this country. I think the last time we had real meaningful improvements was around the ADA in 1990, in the early 1990s. And so, the recent rights that we've been able to gain has been through decisions like the Bostock decision recently, which allows LGBTQ people for the first time to be able to have employment discrimination protections explicitly and comprehensively across the country. Prior to, we could get fired just because, I mentioned my wife on the job and someone felt uncomfortable about it. And that was just, a couple years ago. Prior to that, marriage equality, we were only given those benefits because of the Supreme Court. There were state ballot initiatives in over 24 states to ban a marriage like mine, to my wife in a number of these states. And if not for the Supreme Court, we still wouldn't have the right to marry, the right to have the same legal protections other people have. When it comes to civil rights for Black folks, so when we look at Brown versus Board of Education and rights for women in terms of some of the early wins by Ruth Bader Ginsburg, thanks to Polly Murray, whose memoir is behind me, who drafted a lot of the legal theory, a Black, queer, likely trans trailblazer. We were able to get some of those protections. So often the Supreme Court has done what was needed when those we elect to represent us in Congress failed to do so. The other way around is also true, that the Supreme Court has also gutted the very things that we've needed to be able to thrive in this country, like the Shelby decision in 2013 that gutted the Voting Rights Act. And again, Congress still hasn't acted to address and fix that particular decision. And so, the Supreme Court is important. The Supreme Court is decided by who is in the US Senate. Right now, we have a 50-50 US Senate. What happens next Tuesday in terms of US Senate races across this country will determine who's in decision-making power. When it comes to will be confirmed if we have another vacancy during this presidential administration. And the more progressive of a nominee we want means we have to have more progressives elected to the US Senate. There are a bunch of states that are blackety black in the South where our people can show up and show out like we've done in the past. In Alabama, in North Carolina, we've showed out recently in Louisiana. We can show out at Georgia, right? We can show up in some of these races and really impact whether or not we have the votes, so that if we have a vacancy, we can get someone in who will make sure that the Supreme Court is more on our side than on the side of our oppressors.
Yes, yes, yes to all of that. And thank you for making the connection to the Senate and its impacts on the Supreme Court. I think oftentimes sometimes we feel powerless in this work, but there is some power in our ability to vote. So definitely showing up and let's turn those seats, right? And let's keep those seats that we do have. Indeed.
The Senate isn't gerrymandered, right? In the way the US House is. So when people also get kind of depressed about gerrymandering and how racially motivated a lot of it is, and partisan motivated, US Senate is statewide, right? So people have the opportunity to pick the US senators who will pick, you know, Supreme Court justices and also federal judges, right? And lower courts. We have the opportunity to shape that regardless of some of the ways that people try to harm us with gerrymandering.
Indeed. Appreciate you, Victoria. April, I'll pass it to you. The same question is, how does the Supreme Court decision impact your advocacy work?
Well, I want to say ditto to everything that Victoria said. I think she spoke for us all. And, you know, I will go back to 1857 to Dred Scott and talk about the impact that the Supreme Court has had, you know, on the work that we are still doing right now, you know, and that holding, right, of that case, which is that, you know, the Black man has no right and woman by proxy that a white man is bound to respect. We see that holding finding its way into decisions time and time again. That's the legacy of the Supreme Court that I know, right, and know that still persists today in the work that we do. And, you know, the question of democracy, right, the question of whether or not this country will continue to grow, because, you know, the work that we're doing right now is never been to save democracy, America's democracy. It has always been to shape it and make it into something completely different and new than what it was ever imagined to be. And so when I think about how the Supreme Court continues to impact us, and I see with a razor sharp precision that the decisions that this court is undertaking and the terms that it's had just this year, right, on the question of Black representation, on the question of whether or not Black folk and other people will be able to participate in shaping this country, shaping power, shaping access to resources that our people desperately continue to need, then we understand that this Chief Justice, you know, and the other, and his cohorts, right, his white supremacist cohorts are designing cases that will absolutely take us back to the Dred Scott holding and make it permeate in the same way that that case made it so that even in freed slave states, right, the Dred Scott decision made it so that slaves who were in those states, you know, could not have the protection of the sanctity of their freed status. We find this court making it so that none of us, no matter what state we are in, you know, from the designs of these white supremacist red states creating these laws, this court is nationalizing those laws. And so when we think about the, you know, the Milligan case that we're going to discuss in you know, further, when we think about the Harper case, which this court is going to hear, when we think about the affirmative action cases that you just cited, that we understand that they are trying to usher us back to a place where they're trying to render our power and our voice meaningless. That is how our work is being impacted.
Ashe, yes, to all of that. And thank you for bringing in the concept of design, that this is not, that this is intentional, and that it is a design for failing community, failing educational, this is a design, and that they are advocating on behalf of their strategic plan, essentially to implement this design. And we have to be in position to fight against and also hold our design for the future that we see in the fight. So thank you for lifting those pieces up. I'm going to pass it over to Alec. Same question.
I think there's a number of ways in which the Supreme Court is influencing our advocacy, but I want to broaden the question just a little bit to talk about courts generally, because the vast majority of legal disputes, particularly in civil rights cases, never make their way to the US Supreme Court. They're handled by the lower courts, they're handled by the courts of appeal. And so I think one thing that a lot of people don't pay enough attention to is that the lower courts are even more right-wing and conservative than the Supreme Court. There are many of the lower courts around the country, particularly the courts of appeal, that are sort of even further ahead of the Supreme Court in what I think of as a fascist project. In many of the cases that we see across the country, basic legal principles that one would have thought were relatively well decided and undisputed and uncontroversial at this point are suddenly up for grabs. And there isn't as much public scrutiny on what the lower courts do. And so the lower courts are less constrained than the Supreme Court to follow certain basic norms and rules. And so I think that's quite alarming. It really should be quite scary for a lot of people that what we have is a lower court system that in many respects is less accountable to the public than the US Supreme Court, and even more right-wing. I know it's hard to believe, but that's the situation that we find ourselves in. I want to make a couple of broader remarks, though. So I think in some respects, we're not really at a different situation with the Supreme Court than we've been in throughout the history of this country. If you look at the history of this country, the Supreme Court has always been a reactionary institution, with the possible exception of a few years during the Warren Court era. But it's predominantly been an institution that has not only upheld, but rationalized, tolerated, and even celebrated the greatest injustices in our country's history, whether it was the genocide of indigenous people, the theft of their land, or slavery, or the Jim Crow era, or barring women from voting, or the decisions in the last 50 years around LGBTQ issues, et cetera. You could go on and on and on. The court has never been at the vanguard of social justice. And in fact, I think a big lesson for our work is it can be seductive sometimes when you've got a few liberal justices on the Supreme Court to think that the path to social change is somehow through the courts. But it's never been that way. The path to social change throughout this country's history, at least as I see it, and again, I'm just one person and perhaps somewhat biased, but as I see it, the path to social change in this country's history is one of organizing, is one of struggle, is one of coming together to resist these dominant institutions, cultural norms and narratives, economic systems of inequality. And we can't lose sight of that. And so what I always say to people is, yes, the courts are getting more and more reactionary. And yes, they're dangerous. And we need to think about ways to protect each other and protect our people. But our core task, which is finding a way as lawyers to be a small part of a broader social movement that is working on redistributing power in our society, that is working on organizing poor people, that is working on organizing people of color and immigrants and all people who care about the safety and health of animals and the environment, the natural world. Our task is bringing all those people together in a common struggle against big systems like capitalism. And that is our struggle. That continues to be our struggle. And if we do that struggle well, if we build mutual aid networks, if we organize in our communities together, then the shifts we want on the Supreme Court will follow from that power building. But we can't take shortcuts. And so I think in some weird way, and maybe this is kind of an optimistic point of view, being shown the true colors of the Supreme Court so starkly, I hope will be an impetus for our advocacy and our work for all of us to return to the grassroots work, the base building work, the political power building work that is the absolute foundation of any kind of radical social change.
Like, thank you. Yeah, Ashe to all of that, and bringing in a little bit of the, I think one piece that you talked about, the emphasis on the lower courts, which is super important for us to pay attention to, the importance of organizing. Thank you for bringing in the concept of capitalism, which is, I think, one of the first touch points, I think, thus far, and that this is also interrelated, right? The dismantling of these systems, and then also giving us a little bit of hope about like the visioning of alternatives, which essentially would be held in community, right? And I think that it's also for folks that are like, yo, I'm not gonna vote. There's also a place for you in this work outside of, outside of going to just cast your ballot, right? Like you actually being part of a collective space that is doing mutual aid, that is creating alternatives for our folks, is also part of this movement as well. So thank you for bringing in those lenses to the conversation. And I will pass it to Raya.
Yes.
I hope I did it right this time. Okay.
Yes, it's Raya as in Raya and the Last Dragon. Strangely, Disney made me a whole entire princess, which is a whole entire thing. But yes, thank you so much. I'll have to agree. I don't necessarily agree with I as a grassroots organizer, I agree with the optimism and where the true power lies. I don't necessarily agree with Alec about this newly formulated conservative majority and how this looks different to only a few years ago, in that I think we can safely say at least one of these seats was actually stolen by the political process, arguably two of them. But that said, I absolutely want to double down on the things that folks said before I did. And I want to again mention what you keep hearkening to, Rich, about the organized nature of this strategy and campaign. This has been an absolute legal strategy by the conservative legal community that they have nurtured and inserted into law schools, into journals, into legal thought for many years, half a century. And it is all a part of this coordinated strategy to really roll back all and any advances, however limited they sometimes may seem, that were made by progressive social movements over the past 50, 60 years. I mean, this is literally, what is happening now is the true fruits of a long organizing campaign. And this is something, as all the other lawyers on this call probably know, look at the way just this small piece of something called critical race theory, which was like some unsupported law professors, trying to do some basic thinking. You sit here in dissonance when you learn about the founding fathers and all this stuff. And you're like, wait a minute, can we look at our Constitution and our legal past through a lens that makes sense and takes, history into account? This small thread and how the right wing has taken that and thrown that against us. There's so little support, I think, on the quote unquote left for nurturing Black and brown legal theorists and being able to have this type of movement that is so organized and so well coordinated. So I wanted to speak to that. And of course, I couldn't be more thankful for this forum, because as somebody who focuses on climate environmental justice, and we'll talk later about West Virginia versus EPA and what was done to the administrative state and the administration's ability to regulate emissions that are killing and exposing Black people more than anyone else to toxic pollution. But really, this is about an intersectional, it's an intersectional issue. It is a coordinated attack, and it requires an intersectional womanist response. And so this is exactly, in my opinion, how we should be looking at these, at this collection of issues.
Thank you, and Ashe, for making the connections, and also expanding, really explaining and drawing out that this is part of a larger strategic plan, that this is not just a few racist folks working together. This is
well funded. See, this is what they do. They get together, they make whole entire law schools. They put their friends, it don't matter where they went to school, don't matter if they got two cents to rub together. They get endowed professorships and pens. This is what they do. As they're putting together their agenda.
May I add on real quick, just on this point?
Go ahead.
When you look at what the far right, particularly the Tea Party, did between 2009 and 2016, to me, in many ways, it is its own textbook in terms of what is possible, with some discipline. Just think about it. 2008, they're enraged that Black man becomes president of the United States. 2009, they take over town halls all across this country that members of Congress are doing and literally terrorize. There are members of Congress today still traumatized by the way some of those town halls went. I worked for one. And leverage the power they built from those town halls to take over one chamber of Congress in 2010. And then a couple years later, took over the other chamber of Congress. And then were able to elect President Trump, someone who most people thought for most of the election didn't have a chance in hell to win. Organized state legislatures, this is the real part, organized in state legislatures at the state and local level and governors' races enough that they came 1 to 2 states away from having enough majorities to have a constitutional convention. We have not had a constitutional convention in this country since the nation was founded. And they need 3/4 of the states to do it. And they had like 36, need to get to 38. Who stopped that from happening? Our people. In 2018, we showed up in a midterm election when people didn't think our folks would show up, and came out in record numbers and stopped that from being a pathway for them to completely rewrite our Constitution and the image in which they wanted it to be, right? And then we doubled down in 2020 and gave President Trump his walking papers. So people in this election cycle have kept going back to, what does my vote do? What does it mean? What did it mean? And I have to remind people, 2018 had purpose, because we could be having a completely different conversation about the Supreme Court and the Constitution tonight if people didn't show up and vote then, and then in 2020, and also in that Georgia U.S. Senate race in January of 2021. So I just wanted to underscore what Raya said, that there is power and that there is a concerted plan on the right, and we better have our own concerted plan for what we want to see, what kind of constitutional convention we would plan, to speak to Alex's point around how we might transform, and other points around transforming our systems. They were ready to get there and do that in like 7 years, 7 to 10 years. What does our pathway look like?
Indeed. I'm going to bring a voice in that, Gurleen, same question, and then we're going to go into individual questions. So you have the same question.
I think we can go home after my other panelists have shared what they have shared, which is very powerful. And I want to piggyback on that and say that it is so important that movement lawyering is a part of everything that we do. Because at the end of the day, we must come together to the grassroots organizations, to the communities that are impacted by decisions from the lower courts, from the Supreme Court, from the immigration courts, from every single court within the country, locally, and on the highest court. And because as I stood in front of the Supreme Court earlier this year, understanding the impact of those decisions on Black immigrants, on how people are being taken from community, the pipeline from school to prison, from prison to immigration, from immigration to deportation, it's at the very center of the systematic white supremacy that is guiding every single thing that we are witnessing today. And then when we also see that we have justices that could look like us, but are being used as a tool for white supremacy, right? And we have to make sure we stand behind our new Supreme Court to make sure she's supported, she has the strength behind her to be able to stand against those who are literally fighting for what we want to see. So it is important as we move forward, how does that impact the work that we do at the Haitian Bridge Alliance as we continue to fight for equality, equity within the immigration justice? It is imperative that we come together and we see immigration as a racial justice issue. We see immigration as a domestic women, as gender-based violence issue. We must make sure we integrate that and do not allow the divide and conquer to continue to take root within our community, within our movement, because justice must prevail. And in order for that to happen, we must come together. And as Blacks in the United States, our citizenship does not protect us. At the end of the day, they see a Black woman, a Black man, a Black woman, and a Black man. They don't care if I speak with an accent or not. They don't care if I was born in Haiti or in North Carolina. At the end of the day, the goal of the system is to make sure we are at the bottom. And one thing that I think Victoria, Maya, Alec, everyone, April mentioned, I can share very quickly. I'm in Orange County, California, South Orange County to be precise, if anyone knows where that is. And I have the first Black-led radio station in the county. And during 2018, 2020, I made a point to interview both Republican candidates and Democrat candidates to be able to understand the mindset. One thing that came out of all of those interviews, they are calculated. They planned, they have a message, they are on task, they are on target. And we are the target. We are at the dinner table, we are the meal. And white supremacist is at the very heart and mind of every single thing that they choose to do and how they choose to move forward. So we'll get a little bit more deeper into specific cases, but this is how that impacts my work as a Black woman, as an immigrant woman, as a woman who identify both Haitian and American. And the reality is, unless we move together, unless we include movement lawyering, unless we put our laws centered in people, we have to push through.
I almost forgot I was facilitating. Thank you. Thank you for bringing us back into, I think, the conversation around solidarity in this moment, and what does that actually look like and what the impact is, and also their strategic plan again, and the targeting of Black people. And I love I'm going to quote you on the fact that we are the meal on the plate. We're not at the table, but we're on the plate, and they're making strategic decisions about us. And so thank you for that. And we're going to get directly into questions. My first question is for April. Since 2013, the Supreme Court has twice struck down major portions of the Voting Rights Act. Now, once again, the law is on the chopping block, this time on the question of how state legislatures may draw congressional district lines and when state voters are racially, and when, I'm gonna go back, can draw congressional district lines when the state's voters are racially polarized. Can you break down Alabama's redistricting plan at issues in the Supreme Court and how it will affect Black people?
Yeah, I'm actually licensed to practice in Alabama. I was raised in Alabama. Alabama, and I'm 50, so it's been so yes. And so this case is very, layered meanings for me. It has layered meanings because I am a movement attorney, but it also who has done lawyering in the state of Alabama. And so I understand the magnitude of both the Shelby case that I was actively, involved with, during that time period in my career, and also this most recent case that we see. One of the plaintiff is one of our partner organizations in the state of Alabama with Black Voters Matter, and we do work together. And so this case is significant because in Alabama, there has been one congressional district where Black people have been able to choose their congressional person for many years. And so what we found is that, through the concept of what we call packing, which I know each attorney on this panel tonight understand very well, that they've taken 13 counties and packed all the Black folks into one area. And then they've cracked it, right? And took the other, Black residents in what we call traditionally the Black Belt of Alabama, which is where historically Black people reside in Alabama. And they put them in a district where they cannot have a voice. They could never choose because they are encamped or encased with, members of the white community who have consistently in Alabama either voted Dixiecrat or voted Republican. And so what we found in the decision this year was, a 3-panel court in Alabama made a decision And it was a conservative court, because if all of you know, the 11th Circuit is one of the most, conservative, circuits in the country, decided that indeed the lines were racially gerrymandered in a way in violation of the Voting Rights Act, and determined and decided with the plaintiffs in this case that Black people in Alabama should actually have 2 districts, which we've all known all these years. But the court, in looking at the information, applying the test that has been drafted and recognized historically for Section 2 cases and in these gerrymandering, cases, following that case law, made a decision that indeed the lines were indeed gerrymandered and should be redrawn to allow for, Black people in the state of Alabama to have 2 congressional districts, to be able to choose 2 congressional representation. The Supreme Court, using, a law that is an administrative law, the Purcell versus Gonzalez decision, said that because the elections were too close, it doesn't matter that, the lines, the evidence pointed to racially gerrymandered lines. It was of no consequence, because it was more important that the election administration not be inconvenienced in comparison to the rights of Black folks in this country, in that state, to have representation. Again, Dred Scott, that the Black man has no rights and the white man is bound to respect, because it's more important for the Secretary of State office to be less inconvenienced, right, in elections that were 5 or 6 months away, than it was for Black folks to have, their constitutional right to be able to elect the candidate of their choice. And so that's where we are right now. The court decided it didn't matter. They became a part of, the GOP, and made sure that, Black people or more progressive voices wouldn't have that additional congressional seat this year, right? In order to try to maintain the power that we've talked about by design in this discussion all night. So the court not acting as neutral judges, but acting in a sense as an extension to a political party, in this country. And so we find ourselves with them deciding and looking, at that case. And we've already heard the oral arguments. We know that, Sister Justice Jackson, who found herself there, thank you, Black voters, in the state of Georgia, who brought 2 progressive-minded justices, who also flipped the state that had not been flipped with progressive people for over 30 years, and allow for the breaking vice presidential vote to place her on. And I bring her up that even though this court will more than likely, right, even though, Justice Roberts signaled in the decision, he went against the conservative majority and decided that, it was wrong to apply Purcell. But if you read the decision in the couple of paragraphs that he wrote, he hints it, right, that the court should revisit the long-standing precedent on how they have been deciding Section 2. So we know that Justice Roberts also, since he was a lawyer, right, for the Bush administration, wanted to undo the Voting Rights Act. So even though he didn't decide with the majority in that decision to allow for the racially gerrymandered lines to persist, we know that he wanted this opportunity. He's been seeking this opportunity. He was the chief with Shelby versus Holder. And we know that in this case, he wants to deal that fatal blow to the remaining Section 2 and how it is interpreted to determine whether or not these lines are drawn. So that is where we are right now. We understand, but we are very happy that Justice Jackson turned the originalist argument on its face and reminded them during that oral argument that indeed the Constitution, the 14th Amendment, those particular constitutional amendments that were created specifically to bring protection, to the freed slaves in this country, absolutely have a relevance in this time period. And that it makes no sense that this new emergence that we saw even just this week of them saying that it is unconstitutional to consider race, when in fact these very amendments, right, were created in order to deal with race in this country. And so we understand that we're dealing with that time period, that the case in Alabama has relationship with the case of affirmative action and other cases that are coming before this court dealing with this very important issue, including the Harper decision that's coming up this particular term, where the court is even trying to limit the ability of state courts to look at its own lies and declare them unconstitutional within the state. So that is what we're dealing with right now. These cases have strong implications to whether or not, you know, Black people and other marginalized people will be at the whim of these white supremacists when drawing lines in the state so they cannot have a voice. That is what we're up against. And, you know, but I agree with everybody on here, right? Because believe me, this court, despite the presence of the 14th Amendment, despite the presence of the 13th Amendment and the 15th Amendment, despite the presence of that, this court historically found a way, right, to limit our rights. But despite that, right, our communities have always responded in power, have always marched, have always protested, have always litigated, have always voted, whatever it took. And we've advanced our movement. So like Brother Alex talked about, I fear not, right? Because this court has never, even under the Warren era, right? There were limitations. Even though there were gains, there were limitations. But despite that, our people have always responded in kind. So that's what we're up against with those cases that are dealing with democracy right now. And, you know, we have a fight on our hands, but we're all ready for it.
April, just y'all show some love in the chat as well. There is, so check the chat if you all have access to it. And yes, I'm gonna go right into the next question, which is for Gerline. During the 2021-2022 term, the Supreme Court considered a number of cases that significantly impacted immigration law and policy. For example, Biden versus Texas, centering the Trump era migrant protection protocols. Can you break down which cases before the Supreme Court have an impact on immigration and specifically Black migrants?
Absolutely. Thank you so much, Rich. And April, yes, 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 Lord. Preach, preach, preach. I am so excited. When it comes to immigration, we see, I think Alec is the one who mentioned lower courts. We see how lower courts impact decisions on even who gets access, even who is allowed to get access to public support. We saw the United States v. Santiago. We see Garland v. Dye, on how those are impacted people who might need help and unable to get that because they are fearful of what is called public charge. And there's reports showing who's really receiving social services. Not the Black immigrants, right? Not the Black population at large, actually. The majority of people receiving social benefits are not us. But yet we are being penalized for even thinking about receiving any type of social assistance. And so that is one of the things. The other one is MPP, the migrant, the Remain in Mexico, as they call it, that went into the Supreme Court, and that fortunately they ruled that then President Trump did not have the right to force people to stay in Mexico. And what we saw, the impact on that is people literally dying at the US-Mexico border instead of getting access to asylum. And when it comes for Black immigrants specifically, we can tell you that over 26,000 people have been sent to Haiti under President Biden alone. 26,000 people, including pregnant women and newborn babies. But at the same time, we see how this is very rooted in anti-Black racism, because we are able to quickly receive and provide protection for people from Ukraine. Yes, we should receive them. Yes, we should provide protection for them, but we shouldn't say that we can receive them because the stars have aligned for them. What does that mean for Black people? 26,000 Ukrainians received, 26,000 Haitians, including pregnant women and babies, deported. And so we see the impact of not only the Supreme Court, but the Ninth Circuit, the Fifth Circuit, depends on where they are. In Alabama, in Louisiana, are the belt of where specifically Black immigrants are being imprisoned, caged, deported. So as we move forward, looking into the impact of Supreme Court decisions, it is imperative that we understand also how the lower courts have impacted and continue to impact how this is happening. As we are speaking right now, red states such as Texas and Louisiana are putting their faces together to push against allowing Haitian asylum seekers who are fleeing extreme political turmoil from entering and accessing legal protection based on both US and international laws. So we must pause ourselves and we must answer those questions as to what's guiding, the decisions that are being made. And for Black immigrants specifically, we see that at the end of the day, it might not happen who is in power. At the end of the day, there is a box that people in power, including presidents, that have to follow, because the system itself is rooted in anti-Black racism. And so we really look into those cases, Rich, to see how do we push really hard on community? How do we engage? How do we organize? How do we advocate? And how do we bring our movements together? How do we make sure the same unification that I spoke on earlier today, so that we understand that at the end of the day, we must push for collective liberation, collective freedom, collective justice. Because if we don't do that, we'll continue to spiral down. And I am so grateful for legacy African American, legacy Black people who are standing with and on behalf of the African diaspora, on behalf of immigrants, because our struggles are so interconnected. Our liberation is so interconnected that we cannot do one without the other. So we will continue to push and really look into how do we dismantle the white supremacy within the Supreme Court.
Ashe, once again, and it just reminded me of, we have a saying, or there's also an organization within the FIP movement, that's formerly Incarcerated People's Movement, and that is all of us are none. And the importance of not accepting concessions, because I've said often that the concessions that we accept are killing us. And time after time, we make concessions and accept them, and they end up hurting our people dramatically long term. This is my little one. Welcome to the panel. And so I'm going to go into the next question, and it is for Raya. And we're going to get into the climate piece with everyone. So climate has been a hot button issue. In fact, COP27, the UN Climate Conference, will be taking place for the first time on the continent in Egypt this month. As you prepare for COP27, help break down for us the ruling in West Virginia, EPA, which barred the Environmental Protection Agency from forcing utilities to shift away from fossil fuels and toward renewables. How does this ruling impact Black communities, which are more vulnerable to pollution and other environmental issues? Right.
Thank you for that. And the first thing, yes, I'm glad that you mentioned the COP delegation, because, you know, the International Panel on Climate Change, the world scientists told us just this year that we basically have 10 years left to take action on climate. We know that climate injustice, environmental injustice is impacting frontline communities throughout the entire world, the global South and in the United States. First and worst, it's happening now, and it desperately needs to be addressed. And really, for the first time, I want folks to know that the movement for Black Lives and the Black Hive has taken this up in earnest and is sending, Black lawyers, activists to the COP, where like we supposed to, like we've been supposed to for all this time, because whose struggle is more upfront in an international power play than ours? And it's intentional that our voices are kept out of international conversations on climate, on international human rights, and other matters. So this is just the beginning. There's going to be a climate justice pavilion that is really spearheaded by some of our Black environmental justice movement elders, and the movement for Black Lives will be at the COP with a Black climate mandate. So it's very exciting. I'm honored and proud to be just a small part of it. And so I just want folks to know this struggle, this movement, it's a long game. International negotiations are a long game. And we've always been involved in this game, and we're stepping into this game in earnest. There's a couple things. I mean, what April was talking about, and Gerline, who you say all the things, it's Gerline, talking about when Miss April was talking about, Judge Jackson and the not novel theories, but the common sense legal theories that she's bringing forth, about the 14th Amendment and race. This is part of just hearkening again to the legal scholarship and leadership, which is very often Black men and women and femmes and other people of color who are taking the lead on new ways to think about these things. We need to support these legal theories. We need to build them. We need to have a movement that equals and surpasses what the right wing has done in the legal community. All right, so to get back to, I'll say a couple of things about West Virginia versus EPA. And so there are really two pieces of the agenda that the right wing has long sought to do. One, stop climate action, which, serious action on climate, and two, really rein in and take back the power of the administrative state, or it was a Supreme Court power grab over the administrative state. So what happened is that under an Obama era rule, the EPA, and I want to make another point though, that the Obama era rule that the EPA had forwarded to control greenhouse gas emissions reductions was very controversial within the Black and people of color, Black and brown environmental justice community. Like, I want to say that, like, the rule that what they're not allowed to do was something that a lot of folks in the EJ movement were very skeptical of, because they were concerned that the market-based style or the incentive style mechanism was going to allow the continuation of pollution in Black communities and potentially the concentration of it. So just wanted to say that. But the Obama era rule that was put forward was stayed by the Supreme Court. When the Trump administration came in, Lord have mercy, they tried to replace it with a rule that was so bad that an appeals court struck it down because it basically violated the administration's own obligation to regulate. It was a terrible rule. And so West Virginia then came back to say, Supreme Court, you need to tell the EPA that they can't regulate emissions from the power sector. And I tell this history because just to show how opportunistic this ruling was, because we're talking about a ruling on an administrative rule that never actually took effect. The two things they said, so they said, no, EPA, you don't have the authority to regulate emissions from the power sector in this way. So that was yay, that's what they wanted. But how did they do it? very disturbing doctrine that was unveiled called the Extraordinary Questions Doctrine. So this is something, this power grab from the administrative agencies was really what the right-wing legal community was coming for, and it will reverberate, throughout all decisions that happen. So basically, the Clean Air Act gives the EPA the authority to regulate emissions from the power sector. It really does. But what the Supreme Court said in this instance is that in extraordinary questions, when they're looking at statutory interpretation, or, what does this law mean and what did Congress intend, which is one of the major one of the things that courts do. In extraordinary questions, then they would, in essence, be able to second guess the administrative agency, or like the dissent put it in the ruling, really appointed themselves to be the arbiter of climate policy. What is an extraordinary question? Who knows, really? There's no real solid criteria, except they know that climate action, national climate action is one of those, extraordinary questions. So that is really at the heart of what that ruling did. It both said, no, EPA, you can't regulate emissions for the power sector, which takes a tool from the toolbox for climate advocates. And B, in doing so, it really is a power grab by the courts, who can now step in and basically substitute their own judgment for administrative agency rulings, as they see fit, which is a scary thing.
We're gonna get to, yes, thank you, and Ashe, and thank you for bringing in the intersection of environmental justice in the Supreme Court, and also walking that line around anti-racism that is just kind of like embedded in some of the decisions that folks are making. And so thank you for that. We have a few more questions, and then we're gonna get into some of the Q&A, because there are questions in the chat. So continue to add them. We will get to them as quickly as possible. If you don't get your question answered, we will, I don't know what we'll do. But we'll try to get through all the questions. So Alec, just a couple of days ago, the Supreme Court heard cases challenging affirmative action at Harvard and the University of Northern Carolina, Chapel Hill. What does this mean for admissions at colleges and universities? Go ahead. Well, Alec, I'm sorry.
Yeah, well, let me point out first that, I'm not really an expert on this. I don't work on affirmative action cases. And, so I do a lot of constitutional civil rights litigation, and do a lot of litigation around issues of racial justice, of course. But, I want to just preface by saying, I think my remarks are going to be a little bit less in the weeds of affirmative action, and try to draw out some implications more broadly. So first of all, I think, although the cases were just argued, I think we all everyone who saw the argument and everyone who's been following this court, I think predicts that they will strike down race-conscious admissions at universities in the US. So I think one of the consequences of the court becoming so far right, in tune with the fascist movement, is that their decisions are more easily predictable now. The 6-3 fascist majority on the court is different from, or at least the 5-3-1 fascist majority is different from the sort of hard right 5-4 majority, where there was some interest in one of the justices in maintaining something to do with the integrity of the court for democratic purposes, right? So we're at a different moment now in the Supreme Court. And I think it's easy to predict their decisions. And I think what they'll do is they'll essentially pursue what the conservative project has long sort of thought of as like a race-blind approach to American society. I think, as I was saying earlier, while I think the fascist project in general presents enormous risk to all of our lives, those of us working in this movement, and presents somewhat different set of challenges to the way that we think about lawyering. What does it mean to be a lawyer confronted with a fascist judiciary at all levels? I think those are profound questions we all have to think about. But I do think that some of the core things that we know work are still the same. And it's still about organizing our people around a certain set of narratives that tell a much truer, more compelling, more authentic and honest story about oppression and injustice in our society, and mobilizing people in solidarity with that. And I think that's the same sort of general approach that we have to take with school admissions. One thing that I think is, again, I'm very uncharacteristically going to be a little bit optimistic again in my remarks tonight, just because I'm feeling today like we need a little bit of optimism. And I think if there's something optimistic that can be taken from the court's dismantling of race-conscious admissions, it's that it may finally force universities and schools at various levels to deal with a more anti-capitalist strain of organizing and activism that for a long time has been pushing not for race-conscious admission, but for class-conscious admission. And many Black organizers and activists across the country in a variety of communities of color have been actually pushing the court, pushing sort of activism and courts more generally toward admissions that are taking into account the socioeconomic background of people, which would then kind of ironically do almost approximately the same job at diversifying the racial demographics of these institutions. And there's a reason that the universities chose to go with the race-conscious admissions over the last several decades. And I think that reason has to do a lot with some of the fundamental structural tensions that scholars like Barbara and Karen Fields discuss in their incredible book, Racecraft. I highly recommend reading the book by Barbara and Karen Fields, Racecraft, or listening to one of the many podcasts they've done about it. There's a great one on the Dig Radio where Barbara and Karen Fields talk about this, or the scholarship of people like Femi Taiwo, who's recently wrote a book called Elite Capture, or the scholarship of someone like Toure Reed. And although they're coming at this problem from different angles, I think what Toure Reed and Femi Taiwo and Barbara and Karen Fields are all sort of getting at is that we have to develop new methods of organizing around race that are more conscious of and more directly targeting the ways in which race is being used in the capitalist struggle by wealthy and powerful institutions to create institutions that reproduce a lot of the same inequalities that exist in our society and don't fundamentally address some of the deepest structural inequalities in our society. And I think they've been able to create a bunch of sort of conservative movement fervor around the affirmative action issue. And as a narrative matter, we might be able to finally explain in a more coherent way that is more compelling for sort of mass consumption, the connection between white supremacy and capitalism, and how the conservative project to dismantle race-conscious admissions actually may be an opportunity for us to make a more powerful argument about how the very concept of race throughout this country's entire history has been inextricably linked with the project of capitalism. And so I predict in the wake of this decision, we'll see organizers across the country digging into their racial capitalism theory, and we'll see a lot more political education around how to build campaigns at these universities that are diversifying racially the student bodies, but using a different set of arguments about how universities have been complicit in white supremacy through their perpetuation of and ties to capital and economic inequality. So, I mean, I think I struggle to, we don't know what the decisions are going to say yet, unlike some of these other areas. There's not, we don't know what the exact language will be in the court's decision, but it will strike down race-conscious admissions. And we will see, I think, all of the folks who are working on these racial justice issues pivot to a different sort of narrative. And I hope that the anti-capitalist elements in these in these communities sort of win the battle for how to frame the next fight to diversify elite education.
Indeed, indeed. It sounds like definitely coming out of the Marx bag and like really being able to establish what it sounds like some form of class solidarity through the dismantling of some of the systems, or at least making the connection between capitalism and race, and that they use race, capitalism uses race as a tool to divide working class kind of build towards solidarity, and bringing that aspect to the conversation, and then also calling out fascism for exactly what it is. And I think that is something that I appreciate you bringing to the conversation, is that this is fascism, right? And so thank you for that. And I know we have one more question, and then we're going to get into the broader discussion. So Victoria, it's been a while since we heard from you, and I'm excited to hear from you again. In 2020, the Supreme Court ruled that the 1964 Civil Rights Act protects gay, lesbian, bisexual, and transgender employees. This was seen as a huge win for the LGBTQ community. However, the guidance from that ruling was blocked a year later. Can you break down for us the direction the Supreme Court has gone when it comes to our LGBTQ family, and how will this affect Black people specifically?
Yes.
And I know it's a heavy question, and I think you can answer it because you're brilliant. So,
thank you, brother. It is a heavy question, and Spirit led me to pull down a book in my bookshelf a moment ago about Polly Murray, who I spoke about briefly earlier, because they have a lot to do with the Bostock decision. Polly Murray was someone who was really close to First Lady Eleanor Roosevelt, but also did a lot of advocacy and organizing in the civil rights community and in the women's rights movement. They created what was called the Bible of the Civil Rights Movement, which was used to help knock down a lot of other cases ahead of Brown v. Board, and was used in Brown v. Board. But one of the aspects of their life that many people didn't know about was their advocacy with the Civil Rights Act of 1964. They originally didn't have sex included in the Civil Rights Act of 1964. And Polly Murray, as a Black woman identifying person at the time, said essentially, if you want to include employment protections for Black women, you cannot only include race, you must include sex. So you'll notice in looking at the legislation, sex isn't included in a whole host of other areas of the Civil Rights Act, including public accommodations, which is why Black women laughing on the train can legally get kicked out and not be able to file a discrimination complaint that's specific to the intersection of being both Black and a woman, right? Polly wrote a letter to every member of Congress, the First Lady of the United States, and the President of the United States to ensure that sex was included, to ensure that Black women would be fully protected in the civil rights law, especially in employment, where we were disproportionately being harmed then and still today. It didn't create a paradise for us. But this becomes important in the Bostock decision, because if not for that advocacy, there would have been no lane for which the Bostock decision could have opened up the interpretation of sex to include LGBTQ plus people in the ways in which we queer what people think about people who are assigned different sexes at birth. Polly is the example of why intersectional policy making is critical, because Polly identified as a Black lesbian, probably would identify as a transgender person today if the term was available to them before. And then their advocacy worked to free every part of who they were, including being poor and disabled. And so I wanted to lead into the answer with that, because so many people on this call come to this call with multiple lived experiences, and every single part of who you are is necessary to help free so many people whose stories would not be heard if not through you. Someone continues to ask, what can we do? What can we do? If you feel comfortable, speak your truths, especially the truths that hurt the most. And I'm going to speak one truth that is true for me. After the Bostock decision came out, there were many of my friends and loved ones in the Black community who said, dang, the gay people getting everything. Black folks ain't getting nothing. That was something I heard over and over again. And I kept saying, okay, we got the right to screw who we wanted to screw with the sodomy decision, like 20 years ago. We got the right to marry who we wanted to marry. And now we have a right to not be fired on the job, right? Under President Biden, those are the three rights federally we have through the courts. There's a hate crimes law that became law in 2009. We have don't ask, don't tell. Okay, we can serve in the military freely. But in a whole host of other parts of life, we lack the civil rights protections other Black people have, and also that some disabled people have, although we know we still got more rights to go. The reason why this becomes important in the second part of this question related to some of what has been blocked is that President Biden on the first day of office issued 2 executive orders that I don't think the media covers nearly enough. One was an executive order ordering every single agency in the federal government to get rid of racial inequities that were systemic. And he had an opportunity for open comment for people across the country to share what are your experiences with the federal government where systemic racism has impacted your life. He also issued an executive order that said, same day, the Bostock decision that current statutes that include sex discrimination protections should include LGBTQ plus people because it's based off sex stereotyping, the stereotypes we have based on people's sexual variances or sex-based identity, whether male, female, intersex, etc. That those would be pertinent throughout the different agencies, and that there needed to be rules and a comment period as well to help ensure that those shifts were made. And so we saw agencies push out their plans to implement both of these executive orders. When the Department of Education and the Department of Health and Human Services issued their rules, there were conservative lawmakers who said, we don't really think everybody should be able to live without discrimination. In particular, we don't think transgender people especially should have the opportunity to live without discrimination in education and in health and human services, you know, or in sporting events. And so a number of conservative-led governors and House and state chambers, Senate chambers, state, House and Senate chambers issued, and attorney generals too, issued letters and also filed lawsuits to block some of the protections that the Biden administration sought to give to the LGBTQ plus community. The folks who are most often harmed by these kinds of laws are Black members of the LGBTQ plus community and brown folks, but the people you often see on TV are not. So many people think when we're talking about trans kids being denied the opportunity to play sports, that everyone are white transgender kids who are trying to, you know, play on sporting teams. And there are Black parents whose voices have not been heard, who know that there has been disproportionate harm and bullying, sometimes by school administrators, of their children because of the kinds of policies and rhetoric and laws that follow some of these bans. And so that's part of what we've been pushing back on. And of course, there will be a Supreme Court case eventually, probably addressing these issues and the expansion of the Bostock decision to these other agencies and statutes. And also when we look at the Dobbs decision that just rolled back Roe versus Wade, part of the impact on it is that this court has shown that they don't care about past precedents, regardless of what they said and promised when they were in front of US Senate hearings. They don't believe in holding on to past precedent, which means Supreme Court decisions that have benefited marginalized people in this country, like Roe v. Wade, are all at risk, including the recent Bostock decision, including marriage equality decisions, including past decisions that have had benefit to Black folks and immigrants and a whole host of other communities. And so, you know, we have concern about what this Supreme Court may do to harm us further, and have been working with activists and advocates to ensure that we have a US Senate that's going to confirm nominees to the Supreme Court and lower federal courts as well, because the cases stop there first before they can make it to the Supreme Court. And while we may not have a vacancy for a while in the Supreme Court, we have a ton of vacancies in these lower court levels that President Biden has been, conservatives are doing whatever they can to stop some of these lower court nominees from going through. And if progressives lose the majority, the tie-breaking majority that they have now, it's going to be even harder to move these lower court judicial nominees through the pipeline, which means when these cases make it to that lower level, it's going to be that much harder to be able to make sure that our people have the rights that we frankly deserve, and in many cases already have. So I know it was a really big question. I tried to follow spirit, but also wanted to hit on the different components that were added to it. The very last thing that I'll say is the one thing about executive orders and actions is that when the president leaves the White House, the next president can change it all up. So the Equality Act is a piece of legislation that would add LGBTQ people into existing civil rights law and also modernize and expand existing civil rights law to include better protections for all historically excluded communities. Going back to existing while Black and all the different ways in which people discriminate against Black folks and get away with it, it's because many of those places are not included in current law. Getting discriminated by your Uber driver, or ladies getting charged more at the dry cleaners. Those are things that are not included in current civil rights law that the Equality Act would help ensure. I also think there's an argument that Black hair is an intersecting expression of both our racial and gender identities. And so to the lawyers out there watching, I would love for some of y'all to pursue that legal theory that using the Bostock decision and what it said about gender identity and gender expression and other precedents around, racial identity and expression, that there might be a pathway to achieve some of what we want in the Crown Act through some legal means as well. So anyway, I'm going to end that because I know we're about to get into some group discussion.
Yes. And we got one question. We got a few minutes left, y'all. I'm going to make sure that everybody leaves on time. And so one of the questions that's in the chat that's still open is from Donovan Wilcox. It says, hello, thank you so much for all the inspirational info and ideas. I'm curious about what can be done to create meaningful change in addition to voting and organizing. Is there a way our movements can take significant action to fulfill social justice causes across the country and around the world? I imagine this will be covered throughout, so no pressure to answer directly.
I mean,
I can give a quick answer to this real quick, and that is organize the people, right? I mean, I think that too often this is, it just becomes a siloed conversation. Like, knock on your neighbor's door, their neighbor's door, that neighbor's door, and start having strategic conversations and moving people to our line, right? I think that is extremely important. And just like, I think it's a forgotten tactic that anyone can do. And that's like actually building base and moving people. And that nothing changes without that. And Raya, I saw you had you was coming off mute, so please elaborate.
No, I was just going to say that, we definitely, movement lawyers and everybody, in formation, need to stay the course. I think we need to increasingly, as has been, so eloquently discussed by other folks on this panel, be increasingly intersectional in how we do that, have that womanist lens. I think it's important that we, I love that history that Victoria, you laid out about the thought leadership, of this, Black person, and paving the way for freedom for so many. And that, and keeping the eye on that intersection, I think, is really important. And also, I feel a lot of times like precisely those philosophies and questions just don't get taken seriously, right? Like we're called like foo-foo whatever because we want to have a feminist perspective on climate policy, and folks want to disregard what we're talking about, womanist. Sorry. We need to take our theories, ourselves seriously, support each other, and just double down, triple down on intersectionality. It's just one thing. We're not talking about voting or organizing, but just, one other thing.
Like to just add on to what Raya said. The legal argument in the Bostock decision was something that trans and lawyers of color had been saying a long time, like being literalist, right? Which conservatives say they like, which, might have helped us, and saying that, looking at, sex and, okay, are you treated differently if you marry somebody or, attracted to somebody who is the same sex as you, different than someone of your sex who's attracted to someone who's the opposite sex? It was like a literal, and the answer was yes. Okay, you're being treated differently because of your, as a root cause, because of your sex. It was literal. Same, I had a big frustration around the Dobbs arguments that in our Constitution, there is a definition of who is considered a person, and it starts with the word born in the 14th Amendment. It's in there, it says it. And I couldn't believe that wasn't a part of some of the legal arguments. And so often, to your point, we have these theories that aren't taken seriously. And then when finally somebody invests in them, we win. And we're like, yeah, we've been told you, that was the answer, right? Just like, Black women in Georgia been telling folks, if you give us some money, we can turn this thing out, right? It's like, just believe us when we say it, right? But my original answer to the question before Raya inspired me was, if you come from means, you got a little extra cash, organized money is also really important. Going back to, how the right gets their things funded. You might not have the capacity to organize folks, but if you have the capacity to organize some checks, organize, whatever the modern day version of that, Cash App, to get people together, to get resources to organizations doing the work, to candidates who are going to, promote the issues you care about, that work is also important. And a lot of our people are never asked to give. People assume that we cannot give. And so you look at the donors and contributors of campaigns, and often they look and less like this. And it's often because the assumption is, oh, well, I don't want to ask because they probably can't. And it's like, actually, no, you, just like with anyone else, you ask and see what answer you're going to get. Some of us have the resources and just don't know where to send it to.
Right. Well, we have about 2 minutes left, so I'm not going to open up another question unless you all. I will. Okay, I will. I'll do that. So whoever gets it, gets it. And we'll close out on this, right? So the questions that we have, whether they're additional questions, is how can local communities get involved right now?
I can say activate. We must activate our local communities. We must make sure that people understand that the scarcity mentality has been created to enslave us mentally. And we must make sure we center the reality that our collective freedom liberation is in our hands. We are the ones we have been waiting for, right? And we have the ancestors behind us, with us every step of the way so that we can push through. We must activate. And as Victoria mentioned, we must organize, pull our little money together, and create an avalanche that cannot be denied. We have to make sure that people understand when we enter a room, we take space. We take space for ourselves, for our community, for our ancestors, for those who have died in the Middle Passage, and for our children. Because this is our time, we stand undeterred, and we are going to push through for ourselves. Because Sojourner Truth, MLK, our ancestors, Toussaint Louverture, did not create liberation, did not create freedom, did not create a new world for us to be in the back of the train. So we must activate and we must lead.
That's it. That's a message. Ashe, we must activate and we must lead. So activate and lead. Those are next steps for all of you all. Thank you all for joining us for this discussion. Thank the panelists for amazing intersectional. We talked about it all. We went everywhere with it. And I think that hopefully everybody left with something. And if you didn't get what you needed to get or you want or what you came here for, there's books that were quoted in the chat. And you can pull up those books and get more information. And then also, yep, pull them up. And if you have any additional books, throw them into the chat. I'm sure we'll be following up with everybody as well. So I want to give you all your time and end this on time. Thank you all for being here. Thank you for showing up, and have a blessed evening. Peace.